Hearing the appeal of Soldier Sailors Airmen Family Association against Allgemeines Krankenhaus.
Mr. Doherty, I should say at the outset, I hope I didn't cause too much alarm to yourself and Mr. Hollander this morning by asking that your attention be drawn to a Scottish House of Lords case some years ago that I was involved in. There's no implicit message that this is a critical authority or anything of the kind. It's simply a House of Lords case in this area that I thought you might not otherwise be aware of, and so I thought I should draw it to your attention. That's all.
It's actually referred to in the Captain George's.
Yes. Yes. Very grateful. It is a case that perhaps should have merited a footnote. We decided not, for reasons which I'll come to, as to why we say it is a quite different case, but yes. I will address your lordships on it. My Lords, I appear with Mr. Benjamin Phelps for the appellants, the German hospital, and my learned friend, Mr. Hollander, Queen's Counsel, appears for the respondents. My Lords, this appeal turns on a single point of law, namely whether the Civil Liability Contribution Act 1978 has overriding or extraterritorial effect, such that it applies irrespective of the law otherwise applicable under the relevant choice of law rule. The courts below have held that the 1978 Act does have such extraterritorial or overriding effect, albeit for slightly different reasons. My Lords, this case provides a vivid illustration of the consequences of giving the 1978 Act overriding effect. This is a case where it's common ground that German law would apply to the contribution claim but for the 1978 Act. This reflects the fact that the connecting factors overwhelmingly point to Germany and German law. Any underlying liabilities that the hospital or the respondents might have to the claimants are subject to German law. All the underlying events took place in Germany. It's also agreed that under German law, limitation has expired. The date that limitation expired is not agreed, but it is pleaded in the hospital's case as having expired not later than 2008. Indeed, in the light of a judgment by Mrs. Justice Foster in a trial on limitation as between the claimants and the respondents, and in the light of her findings on knowledge, it's likely, in fact, that time expired in 2006. Nothing turns on those precise dates. But the key point to note is that some 8 to 10 years passed by after the expiry of German law and the commencement of proceedings by the respondents against the German hospital in 2016. Yet, because this claim has been issued in England, my German clients face having to deal with a contribution claim that has long since expired as a matter of German law. And we say that that is wrong as a matter of principle, authority, and construction of the 1978 Act.
And presumably, as I understand it, the limitation period in Germany had the effect of being a procedural time bar rather than extinguishing the substantive right.
That's right, Lord. Lord, can I make 2 introductory observations? First, in this case, there is a difference between the 1978 Act and German law in relation to limitation. Of course, in many other cases, the differences may be other. It may relate to what wrongs contribution applies to. And your lordships will have noted that under the 1935 Act, contribution was limited to tort, not to other wrongs. Many Commonwealth jurisdictions still base their laws of contribution on the 1935 Act. The difference may go to how contribution is assessed. Is it equal shares, as it was under equity? Is it based on blameworthiness or causation or a combination? and it may even go to whether there is a right of contribution at all. And if the 1978 Act has overriding effect, all these differences are simply ignored. Second, although this is a pre-Rome II case, in that the relevant events took place before the 11th of January 2009, the question of overriding effect has ongoing relevance. And it's a point that we address in our written case, page 38 of the electronic bundle, page 7. And it has ongoing relevance because, first, there are in fact a surprising number of pre-Rome II, what we might call long-tail cases, cases relating to minors, mesothelioma, colonial abuse. And second, because it remains relevant under Rome II. Now, your lordships may have seen from the written case that under Rome II, there is a specific provision in relation to choice of law for contribution, Article 20. And perhaps if I ask your lordships to look at it, because it will tie into a point that I make later. And your lordships can find Rome II in the electronic bundle at page 297. And the express choice of law is at page 304. Article 20, multiple liability. But Rome II also includes a provision in relation to overriding mandatory provisions, which can be found at Article 16 on the preceding page 303, which provides that nothing in this regulation shall restrict the application of provisions of law of the forum in a situation where they are mandatory, irrespective of the law otherwise applicable to the non-contractual obligation. And, my Lord, of course, the first question to be addressed as to whether the 1978 Act has such an effect is its construction as a matter of domestic law. I accept that there is then a second question as to whether that construction of the purpose and effect of the Act is sufficient to meet the requirements of Article 16 of the regulation as now domesticated into UK law. That may be a different answer, and there's a debate about that in the commentaries. What I would say simply by way of observation, is the case law to date suggests that the approach to Rome II and Article 16 marries with that set out by Lord Sumption in Cox. And that's a point that emerges from the decision of CIRED and PZU, a decision of Mr. Justice Sewell, construing whether the Social Security Recovery of Benefits Act 1997 has overriding effect or not under Rome II. And I don't intend to turn that up, but the reference, my Lord, to CIRED is 714, and the relevant passage is at 736. So, Lord, these are questions that are obviously important for this case, but have ongoing importance as well. Now, in terms of the structure of my submissions, I propose to begin by looking at what we say is the correct starting point of the analysis, and to consider the principles that we say underlie choice of law and the presumption. I'll then move on to what we say is the key authority in this area, Cox and Ergo, before considering two more recent decisions of this court on extraterritorial effect, albeit focused on conduct rather than choice of law cases.
I know that language has been used in Cox and in the judgments below, but it isn't really an issue of extraterritorial effect, is it?
Well, but I was going to come to that. Your Lordship will have seen from our written case that we don't consider that the appropriate language is extraterritorial effect. We've used overriding effect or overriding mandatory effect below. That's the language that Mr. Justice Sewell used, we say correctly. The Court of Appeal chose not to use our language. They used the language of extraterritorial effect. One can understand why, because if one looks at Cox, when we come to see it, we'll see that that was how the argument was addressed to this court, albeit it's not how we say it was analysed. But, Lord, I'll come back to that, but the point is, if I may say so, a good one, my Lord. I will then turn to consider the 1978 Act in the light of the guidance. Thereafter, I'll move on to the legislative history of the 1978 Act, the context in which it was enacted, as well as looking at some of the academic commentary in this area. And finally, I'll address the relevance of some of the cases that my learned friend refers to in his written case. But, Lord, if I can start by identifying what we say is the correct starting point for the analysis. And it's a fairly simple one. Does one start with the Act, or does one start with choice of law? Now, of course, I accept at the beginning that it won't necessarily make a difference. If you are looking at both of them, you may still end up with the same conclusion. But as a matter of principle, it does make a difference, and indeed in certain circumstances, it may make a difference in terms of the result as well. And your Lordship will have seen from our written case that certainly on our analysis of the Court of Appeal, they very firmly started with the Act, and indeed the reference to extraterritorial effects, the analysis of Cox, was very much, in Lord Justice Irwin's judgment, a postscript, analysing the conclusion to which the court had already come as a matter of statutory construction. That approach is consistent with the approach that Mr. Justice Chadwick took in the Arab Monetary Fund and Hashim case. It is, in fact, inconsistent with the approach that Mr. Justice Sewell took, who firmly started off by considering the relevant choice of law analysis before moving on as to whether that could be displaced. Now, obviously, I'm conscious that I lost both before Mr. Justice Sewell and the Court of Appeal, so the starting point doesn't necessarily tell you the result. But in my submission, it is an important point of principle to get right. And we say that there are good reasons why one starts with the choice of law question, or the preliminary choice of law question, as Mr. Justice Chadwick put it. The most obvious one is that it reflects the very purpose of choice of law rules, which is to select, in a case which has foreign elements, the system of law with which the issue is most closely connected. That is why one has choice of law rules. So in the context of tort, one has a choice of law rule that may depend on the law of the place of the damage, or the law of the place where the event's giving rise to the damage. The rules may be different, but they reflect a decision of the forum as to the connecting factors that are relevant in connecting the issue with a system of law. And that justification, it can be seen by stepping back and understanding the justification for conflict of laws more generally. And it's quite elegantly, in my submission, summarised by Lord Nichols in the Kuwait Airways case. And if I could ask your lordships to turn to that case, it's page 555 of the electronic bundle. The facts don't much matter, but as your lordship's probably aware, it related to the effect of an Iraqi resolution. I think it was Resolution 369 of the Iraqi government following the invasion of Kuwait on the ownership of certain planes previously owned, at least, by Kuwait Airways. And there was no issue that Iraqi law applied, and the question was whether that resolution, or one of the questions was whether that resolution 369 should be recognised. But for present purposes, it's the more general point that's relevant, and one can see that page 566, paragraph 15 of the judgment of Lord Nichols. And he says there, conflict of laws jurisprudence is concerned essentially with the just disposal of proceedings having a foreign element. The jurisprudence is founded on the recognition that in proceedings having connections with more than one country, an issue brought before a court in one country may be more appropriately decided by reference to the laws of another country, even though those laws are different from the law of the forum court. The laws of the other country may have adopted solutions or even basic principles rejected by the law of the forum country. These differences do not in themselves furnish reason why the forum court should decline to apply the foreign law. On the contrary, the existence of the differences is the very reason why it may be appropriate for the forum court to have recourse to the foreign law. If the laws of all countries were uniform, there would be no conflict of laws. Now, Lord, a fairly basic proposition, but an essential one when the question is whether one starts with conflict of laws or the statute, in my submission. The position is also pithily put by the editors of Dicey and Morris, who underlined that the justification of conflict of laws can be found by looking at and identifying the legitimate expectation of the parties. And we can see that at page 1106 of the bundle. Paragraph 1005 in the chapter Preliminary Matters, Justification. What justification is there for the existence of the conflict of laws? Why should we depart from the rules of our own law? Sorry, my lord. Of our own law and apply those of another system. This is a vital matter on which it is necessary to be clear before we proceed any further. The main justification for the conflict of laws is that it implements the reasonable and legitimate expectation of the parties to a transaction or occurrence. And we can find additional justifications grounded in policy, applying the conflict of laws and the relevant choice of law reduces the incentive for forum shopping compared to a situation where the forum only ever applies its own laws. And finally, and I said to your lordships that there may be occasions where it does matter where you start, the choice of law rules may themselves contain rules as to when they should be disapplied. I've taken your lordships already to Rome 2. Perhaps the more obvious one is Rome 1, and of course the 78 Act applies both to contracts and to torts. And if your lordships turn to page 293 of the bundle, Article 9, your lordships will see another provision in relation to overriding mandatory provisions, which is slightly fuller than the one set out in Rome 2. Overriding mandatory provisions are provisions the respect for which is regarded as crucial by a country for safeguarding its public interests, such as its political, social, or economic organisation, to such an extent that they are applicable to any situation falling within their scope, irrespective of the law otherwise applicable to the contract under this regulation. So there's obviously there's some debate as to whether that has the same meaning as Article 16 in Rome 2. In my submission, it probably does, but that's not a question that your lordships have to grapple with today. And we can see that from the material behind Rome 2. But the relevant point here is that the choice of law rules themselves are setting out the circumstances in which they may be disapplied. So if one does what Mr. Justice Chadwick did in the Hashim case and says, is the answer supplied by the Act itself, one would be ignoring the choice of law rule which itself provides the answer to its disapplication or not. So we say that's an example of where there may be a difference as to where you start. But in any event, we say that all those factors provide principled reasons why one should start with the question of law, of the choice of law. And that, my lords, takes me to the related question of the presumption. And as my Lord Reid has already outlined, our position is certainly that when we come to terminology, it is better here to refer to the presumption against overriding effect rather than the presumption against extraterritorial effect. While certainly one can find in the cases reference to extraterritoriality, which relates to choice of law, it is less apt. Extraterritorial effect is more obviously concerned with conduct outside the jurisdiction, regulating conduct outside the jurisdiction, not in relation to the question of choice of law. And I know my learned friend agrees with that. That was the position of Mr. Justice Sewell. Obviously, the Court of Appeal took a slightly different view in terms of the terminology.
Mr. Doherty, I can understand the use of the term presumption if we're talking about extraterritorial effect. But if it's simply a case of whether it has overriding effect or not, I mean, is it strictly a presumption, or is it no more than the displacement of the normal starting point?
Well, my Lord, that takes me on, therefore, to what is the justification of presumption, because it's an entirely fair point that as soon as one recognises that they are different, the justification for what is the presumption against extraterritorial effect, which is commonly given as the futility of seeking to regulate conduct outside the jurisdiction, comity, international law, does not apply, or certainly not on traditional English views, does not apply to displacement of choice of law. There's a bit of a debate as to whether comity is relevant for choice of law or not. The traditional view in this jurisdiction is that it isn't. We say that the foundation for that presumption, the presumption that this court explicitly recognised in the context of choice of law in Cox, is instead the factors that I've already outlined. Namely, it is the link to the legitimate expectations of the parties, that where there are cases with a foreign element, you would expect the court to take account of those elements, or as Lord Nichols perhaps puts it more broadly, that conflict of laws is about doing justice between the parties in cases with foreign elements. And in very crude terms, that itself represents a policy imperative. So we say that what Lord Nichols says, what Dicey and Morris say as part of their general justification, really in the context of conflicts of displacing the choice of law, becomes the main point. There's another difference which is perhaps worth drawing out as well. When one talks about extraterritorial effect in relation to conduct, it's often a one-way street. There isn't a countervailing rule, I mean, perhaps other than international law, pointing in the other direction. Whereas in the context of choice of law, what one has is a common law rule or a statutory rule, choice of law rule, being balanced against a statute that potentially has the effect of ousting it. And so in that circumstance, one is having to balance two rules, something which the court doesn't need to grapple with typically where extraterritorial effect in the stricter sense applies. So your Lordship will see when we come to Cox that, in my view, in my submission, that there is no doubt that the presumption exists in relation to choice of law, and that's the effect of Cox. But its justification has to be found from a different source from that involving the regulation of conduct outside the jurisdiction. My Lords, perhaps with that, I'll turn to the decision of this court in Cox and Ergo Versicherung. And the decision can be found at page 617 of the electronic bundle. Now, my Lords, this was also a pre-Rome II case. The underlying dispute arose out of a fatal road traffic accident in Germany. It was agreed that German law governed liability, but the claimants sought to argue that the Fatal Accidents Act applied in relation to the assessment of damages. And that was because English law provided for a more generous outcome. In particular, it provided for payment of damages in respect of bereavement, and also provided for certain benefits to be disregarded. For example, no credit needed to be given for remarriage in particular. And, Lord, if we turn to paragraph 12 of the judgment of Lord Sumption, with whom my Lord Hodge agreed, as well as Lord Neuberger, Lord Toulson, we can see the issue set out there. And taking it just from E, the issue in the present case is whether Mrs. Fox is entitled to rely on the provisions of Section 3 and 4 of the Fatal Accidents Act. They provide for a measure of damages substantially more favourable, and then we can skip. This issue depends on whether the damages rules in Sections 1A and 3 of the Fatal Accidents Act fall to be applied on 1. Ordinary principles of private international law as procedural rules of the forum, or 2. As rules applicable irrespective of the ordinary principles of private international law. Now, Lord, in relation to the first point, this court concluded that the Fatal Accident Act wasn't to be treated as procedural, such as to apply in any event. In fact, Lord Sumption said there was a sort of simpler answer, which is that on either view, the Act wasn't apt to apply on its own terms. But the second argument, an independent argument, was that the claimant said, well, in any event, the Fatal Accidents Act as a whole, not specifically, as a whole, one can see that from the argument, had overriding effect. And it was put in two different ways. One was that it had extraterritorial effect, and the other was that it was mandatory in effect. Now, a short point aside here, Lord Justice Irwin said that the decision on the second point was strictly obiter. With respect, we disagree. They were both independent grounds. The claimant could have succeeded on either. And so, Lord, it's difficult to understand how it could be treated as being obiter. That said, to be fair to Lord Justice Irwin, he then went to consider them. So he didn't fail to apply them. But we do say that his observation on the status of Cox is incorrect. Lord, can I pick it up then where Lord Sumption starts dealing with the second issue at paragraph 24? And your Lordships will see that he heads this issue as overriding effect of English law. So although it's been put under two heads for him, he's grouped them together. At paragraph 26, one can see the argument that's been put. Mr. Leighton argued that the Fatal Accidents Act should be applied notwithstanding the ordinary rules of private international law for two reasons. His first submission was that as a matter of construction, the Act had extraterritorial effect. His second submission was that the principles enacted in the Act represented mandatory rules of English law, applicable irrespective of ordinary rules of private international law. For reasons that will become apparent, I regard both submissions as raising the same issue in the circumstance of this case and as requiring the same negative answer. But he then deals with them separately, and under the first heading, extraterritorial effect, he starts considering the question of construction and the presumption. Whether an English statute applies extraterritorially depends on its construction. There is, however, a presumption against extraterritorial application, which is more or less strong on the subject matter. It arises from the fact that, except in relation to acts of its own citizens abroad and certain crimes of universal jurisdiction, such as torture and genocide, the exercise of extraterritorial jurisdiction is contrary to ordinary principles of international law governing the jurisdiction of states. So, pausing there, that is, of course, right for extraterritorial effect, but when one comes to a choice of law, my submission would be one needs a slightly more refined justification for the presumption, even if the principles of construction are the same.
But is he talking about what you've called conduct questions there? Looks like it, doesn't it?
Well, it does, and he certainly then goes on to refer to Clark and Oceanic Contractors, which is a conduct case. I mean, Clark, as your lordships may have seen from the bundle, that's a case about the operation of a PAYE system by an overseas company, and whether it was required to operate a PAYE system, even though it was outside the jurisdiction. But the language, which is then the language that Lord Sumption appears to be adopting when it comes to choice of law, we would say is the same. And it's
Well, is it? You see, the reason he gives for the presumption is that the exercise of extraterritorial jurisdiction is contrary to ordinary principles of international law governing the jurisdiction of states, which is, isn't it, you legislate for your own territory and not other people's.
Yes, no, so I certainly accept that the justification is different. The point I was seeking to make was that when he then quotes from Lord Scarman and what we see later, he appears to be drawing in that analysis of construction more generally to the choice of law context. Because obviously Cox is a disapplication of choice of law, and what is clear in my submission is that what is being done by the court is to apply those principles to choice of law. Now, it may be that the justification given needs some adjustment, but the principles adopted in my submission, namely the approach to construction, are the same for the reasons I've given previously. The justification, although the justification is different, the rules of construction should be the same. And in that, sorry.
Well, I mean, the strength of the presumption against extraterritorial effect derives from the interference that it represents with the sovereignty of another nation, essentially. Yes. And that's not what we're talking about if we're simply talking about a choice of law rule, I don't think.
No, Lord, I accept that when one starts talking about strength of presumption, or the strength of the evidence necessary to displace a presumption, it doesn't matter which way round one looks at it, then, of course, the context will be very different. But if one looks at, for example, the language of Lord Scarman in Clark, so where he says, unless the contrary is expressly enacted or so plainly implied that the courts must give effect to it, the United Kingdom legislation is applicable only to British subjects or to foreigners who, by coming to the United Kingdom, whether for a short or a long time, have made themselves subject to the British jurisdiction. What I say is that obviously that is a different context, but the language of expressly enacted, well, that's obviously uncontroversial. But the second bit, so plainly implied, is also what I say the relevant test is, and certainly what, in my submission, Lord Sumption is doing later on when he sets out the two bases upon which implication can be made. Now, in paragraph 28, Lord Sumption moves slightly closer to the choice, well, in fact, moves to the choice of law analysis, because he makes the point that there is a distinction between cases where really the question is, does English law apply as a matter of choice of law, in which case there is no question of extraterritorial effect. And those cases, picking up just above E, the second question is one of extraterritorial application properly so called. It is the question posed by Section 14.3a of the Private International Law Miscellaneous Provisions Act, 1995, which had its counterpart in the common law, namely whether the choice of law arrived at in accordance with Sections 11 and 12 is displaced by some mandatory rule of the forum. This is not a choice of law principle at all, but turns on the overriding rules of policy of the forum. So at that point, obviously, Lord Sumption has in mind the question of choice of law being disapplied as a result of some overriding mandatory rule. And then we get to paragraph 29, which is perhaps the key paragraph.
But just, I'm sorry to interrupt again, Delty, but you say this is not a choice of law principle at all. You've been explaining to us that the whole point about the corpus of choice of law rules is that they may contain within them provisions for their own disapplication. That's what's being considered here, isn't it?
Well, my Lord, that may again be a question of terminology. Certainly, I perhaps wouldn't have written it as Lord Sumption has, but he obviously wasn't addressing this question. I think the point that Lord Sumption is making is simply you have the choice of law rule derived by the relevant rule, and then there is a separate question as to whether the law of the forum requires that to be disapplied as a result of some policy. And that's the overriding effect of it. I mean, and that's why he's saying that's not a choice of law rule. You get the choice of law rule first, then you consider whether it's disapplied. I mean, the rules for the disapplication may, of course, sometimes be found in the overall choice of law rules.
Thank you.
Paragraph 29 is perhaps the key passage. And there he sets out the approach. In the present case, it's common ground the lex causae arrived at on ordinary principles of private international law is not English, but German law. There is nothing in the language of the Fatal Accidents Act to suggest that its provisions were intended to apply irrespective of the choice of law derived from ordinary principles of private international law. Such an intention would therefore have to be implied. Implied extraterritorial effect is certainly possible, and there are a number of examples of it. But in most, if not all cases, it will arise only if the terms of the legislation cannot effectually be applied, or its purpose cannot effectually be achieved unless it has extraterritorial effect, or the legislation gives effect to a policy so significant in the law of the forum that Parliament must be assumed to have intended the policy to apply to anyone resorting to an English court, regardless of the law that would otherwise apply. So, my Lord.
And are we going to find those propositions extracted from some other authority somewhere?
No, my Lord. I mean,
they've just come from Lord Sumption.
My Lord, what they are, in my submission, is a recognition of what is necessary in order to do it in circumstances where there is a presumption. So, look, if I can just analyse what we say, how this paragraph should be understood. There's clearly a distinction being drawn between express and implied extraterritorial effect. It's binary. And although it is right to say that the language talks about there's nothing in the language to suggest that its provisions are intended to apply, given what follows, I reference to implication, that is a reference to express effect.
Yeah.
Now, I'll come on to what I mean by express effect, but in this context, I can identify it now. Express effect means that you say in terms that you disapply, using similar words, the choice of law that would otherwise apply. It is not a matter of simply saying it is implied from the word, that they are distinct. So the first option is express. Then he deals with the question of implication. Now pausing there, I would certainly accept this. Lord Sumption is not there trying to set out all the rules of construction of a statute. And in particular, clearly, when one's construing a statute, one will always want to look at its wording, its purpose, its scheme, its context. And I'll come to the KBR decision and the judgment of my Lord Lloyd Jones, which makes that point. But in my submission, the point that Lord Sumption is making is a narrow one, which is saying that once you've carried out that exercise, unless you satisfy, so in a way, the rules of construction are the process, what he's setting out there is what the result needs to be. Because unless you satisfy the requirements of the purpose not being effectually achieved, or the policy being such an important one, or the provisions not being effectually achieved, it's very unlikely that Parliament will have intended to displace the choice of law rule. And obviously here, in this context, we're talking about choice of law. And that comes back to my earlier point about saying, well, that there is a policy reason to apply choice of law in the first place. It's not a neutral point. There is a positive reason behind it. And Parliament should not be seen as intending to override that choice unless one satisfies those requirements. I said, that doesn't tell you the process by which you get there, but what Lord Sumption in my submission helpfully and authoritatively does is identify what you would expect. Now, obviously, I don't seek to go any further than Lord Sumption and suggest that that is necessarily exhaustive, and Lord Sumption doesn't say it's necessarily exhaustive, albeit he seems to suggest that it might be. But it is difficult to think of a situation where you do not in express terms say that something is to override choice of law, and what you are relying for an implied effect does not satisfy the bases set out by Lord Sumption, i.e. it's not necessary to give the terms effect, it's not necessary to achieve the policy or the purpose of the legislation, and it doesn't represent a policy so important that Parliament must be presumed for it to apply in any event.
I know, as always, one doesn't construe, doesn't approach a judgment as if it were a statute to be construed in that kind of a way. But that said, if you look at what Lord Sumption actually says between F and G, he says there is nothing in the language of the Act to suggest that its provisions were intended to apply irrespective of ordinary principles. Now, that way of putting it doesn't confine, is not confined to an express statement. He's saying there's nothing to suggest. So, I mean, that would cover, I would have thought, an ordinary implication. Admittedly, he then goes on to talk about implied extraterritorial effect, and he confines it between G and H to effectively implication by necessity, or implication as a matter of overriding public policy.
Yes.
But the introductory language that he's used suggests that an ordinary implication is another possibility. Well,
Lord, I understand that point because the word suggested, and I understand that. And it's a point that the Court of Appeal and Lord Justice Owen appears to have taken on board to say that, well, he doesn't actually need to get to implied effect because as long as he concludes that it's suggested, that's sufficient. But in my submission, that simply can't be the proper understanding of that paragraph for two reasons. The first is that it's in the context of having set out in Clark what the general rule is. It's expressly enacted, and one goes back there just under B, unless the contrary is expressly enacted, or so plainly to be implied. So those appear to be the binary provisions that he's not seeking to depart from. He's put this under the heading of extraterritorial effect. He's set out the general position. There are two options, expressly enacted, so plainly to be implied. He's dealing in 29 first, in my submission, with expressly enacting. Yes, the language, it could be read to be broader, but in my submission, it can't be in the light of what he's referred to. And any doubt that one has is then removed by saying such an intention would therefore have to be implied. Therefore, assuming, as my Lord Regis pointed out, that there is a distinction. So my answer is that, yes, I accept the word suggested is perhaps not the clearest, but when one unpacks it, to use that unattractive phrase, in my submission, it is tolerably clear that one is comparing express provision and implied provision. And again, if one stands back, that's also the principled answer. Because if one tests it the other way and says, well, actually, can you have an implied effect which doesn't satisfy the second requirements? Well, first, it gives no meaning to the second part of that paragraph. And the second is that you then fail to give really any effect to a presumption. The whole context of this is to say that there is a presumption. The courts should be slow to depart from the presumption. Yes, it's context specific. In this context, we're talking about a choice of law rule that is either statutory or common law. And one shouldn't assume that Parliament is intending to set it by one side unless there is something more. That can't be implication. Without more, in my submission, it needs to be so plainly implied, and that type of clarity will only be achieved if one, will almost only be achieved if one satisfies one of the two bases set out by Lord Sumption.
We have to bear in mind, don't we, that when Lord Scarman said what he said in Clark, that was what anybody would understand to be a case about extraterritorial effect. I mean, it's an attempt to impose requirements under UK tax law on somebody outside the UK.
Yes, look, and I accept that. I mean, it's at the heart of my submissions that there must be different justification. But what, in my submission, Lord Sumption is doing by putting this under this heading, and to be fair to Lord Sumption, it's the heading in which it appears to have been argued. So he was addressing the argument that was put. It is to deal with the overall principle set out from Lord Scarman's speech, what appears to be the essential requirement in order to displace the presumption, I express also plainly to be implied, and then develops it. So that's why, although I accept it's in a different context, it is implicit in my submission that Lord Sumption still considers that to be the relevant overall test, the binary test, and that implication needs to be plainly applied. And that fits with what paragraph 29 says and the two bases. Now, after that, Lord Sumption moves on to consider the case law first under the Fatal Accidents Act, which had previously been regarded as extraterritorial in effect, and essentially reanalyses it as really involving choice of law rules. And similarly, in paragraph 31, he analyses the employment cases as really raising choice of law questions rather than questions of territoriality. He then moves to the Fatal Accidents Act at paragraph 32, and he gives another number of reasons for his conclusion why the Fatal Accidents Act doesn't have extraterritorial effect. And starting at paragraph 32, Fatal Accidents Act 1976 is an unpromising candidate for implied extraterritorial effect. And the first point that's made is not one that's applicable here, because it's specifically relating to the tort question and the double actionability rule, whereas obviously contribution is a broader concept. But then paragraph 33 is more analogous. Secondly, the whole purpose of Section 1 of the Fatal Accidents Act was to correct an anomaly in the English law of tort. There is nothing in the mischief of the legislation which requires it to be applied to fatal accidents being governed by foreign laws, which, being governed by foreign laws, are unlikely to exhibit the same anomaly. If there is no reason of policy to apply Section 1 to foreign torts, there can be no better reason to apply Sections 1A, 3 and 4, which depend on Section 1. Thirdly, there is no reason whatsoever why Parliament should have intended the Fatal Accidents Act to apply to foreign fatal accidents with no connection to England or English law. Neither the terms nor the purpose of the Act depend for their effect on its having extraterritorial effect. The only other basis for imputing to Parliament an intention to apply the Act internationally, irrespective of ordinary rules of private international law, is that the Act, and in particular its damages rules, represent a mandatory rule. This is the expression commonly employed to describe what the law commissions of England and Wales have called rules of domestic law regarded as so important that as a matter of construction they must apply in any action before a court of the forum, etc., referring to the 1984 Law Commission working paper on tort and delict. Section 14.3 of the Private International Law Act 95 have the effect of saving such rules. Some foreign laws governing the availability of damages for fatal accidents may no doubt be so offensive to English legal policy that the effect would not be given to them in an English court. A rule of foreign law that women or ethnic minorities should have half the damages awardable to white males, similarly placed, was cited as an example. The German rules with which this case is concerned are based on a perfectly orthodox principle which is by no means unjust and is accepted in principle by English common law in every other context than statutory liability for fatal accidents. And then in paragraph 35, he refers to the second way that it's been argued mandatory rules. It must follow from the reasons for rejecting implied extraterritorial application of the Fatal Accidents Act that Mr. Layton's second submission, based on the mandatory character of the rules, also fails. And then, just for reference, paragraph 51, Lord Mance expressly agrees with the points made by Lord Sumption on extraterritorial
I'm going back
effect.
quite a long way, Mr. Doctor, and probably wrongly, but as I recall, there was an enormous fuss, to put it in very simple terms, about the rules for particularly the effects of remarriage, which were altered by the Fatal Accidents Act.
Yes.
It was regarded as a cause of some significance by many pressure groups.
Yes. Yes, Lord, it was a controversial provision, I mean, both ways, because obviously it changed what the normal assessment of damages would have been,
Right.
albeit regarded for policy reasons that it should be done. And so one can see that argument both ways.
It was all policy, wasn't it?
Yes. And so at one level one could say, well, isn't that a good example of a policy that should be translated more generally? Obviously, Lord Sumption decided and concluded not, but that's very far away and removed from this case, where we say there's really no policy at all which would justify disapplying the Act. Applying the Act when the choice of law rules point to another system of law. Lord, I'm just going to refer relatively briefly to two decisions of this court post-Cox. The Bilter and Nazir decision and the recent decision in KBR, the judgment of my Lord Jones. Lord, turning first to the Bilter and Nazir case, that was an alleged VAT fraud, and it was a claim by liquidators of a British company who was seeking to claim against parties in France and Switzerland who are said to be party to a fraudulent scheme. And the claim was made under Section 213 of the Insolvency Act, which it was said could not operate extraterritorially. And the aim was to seek a contribution to the assets of the British company, which was being wound up. The point about extraterritoriality was considered by Lord Sumption and also by my Lord Hodge and Lord Toulson. And I can just take your lordships to that briefly, because in my submission it's an application, albeit again in a case involving conduct or in relation to the winding up of an English company, and as to whether that should fall within the scope of the provisions for making good the assets of the company, it still involved an application of the same principle and underlines what we say is really necessary when one is going to imply extraterritorial effect. In that case, for conduct, we say more generally in relation to choice of law. The first passage is at page 683. The case starts at 639. And it's the judgment of Lord Sumption at 108. And then this is under the section Insolvency Act 106. It's a short point and straightforward one.
This rather looks as though it is truly a situation concerned with extraterritorial effect.
Yes, most of the cases are. I mean, there are a few examples of cases where it may be said to be in the choice of law. Syrid and PZU is one such case. The Deutsche Bahn and MasterCard case at 752 may be another such case. But on the whole, most of the cases are cases referring to conduct outside the jurisdiction. Yep. And the justification that Lord Sumption finds for the Act having extraterritorial effect can be found at 108. Most codes of insolvency law contain provisions empowering the court to make orders setting aside certain classes of transaction which preceded the commencement of the liquidation and may have contributed to the company's insolvency or depleted insolvent estate. They will usually be accompanied by powers to require those responsible to make good the loss to the estate for the benefit of creditors. Such powers have been part of the corporate insolvency law of the United Kingdom for many years. In the case of a company trading internationally, it is difficult to see how such provisions can achieve their object if their effect is confined to the United Kingdom. And the judge, and Lord Sumption then moves on to consider the related case of In re Paramount on another provision of the Insolvency Act, which was also held to be extraterritorial and approved of those the points made there. But the key point being the identification that the terms, that the object can't be effectually achieved unless it has extraterritorial effect. And in a similar way, if one turns to paragraph 212, which is on page 711, of the judgment of Lord Toulson and my Lord Hodge, again under the section Insolvency Act, section 213, one can see first in paragraph 212 the reference to the relevant principles to be applied, and at the bottom a reference to Cox, just above H. In Cox, Lord Sumption suggests that an intention to give a statute extraterritorial effect could be implied if the purpose of the legislation could not effectually be achieved without such effect. And then in 213, in our view, section 213 has extraterritorial effect. Its context is the winding up of a company registered in Great Britain. In theory, at least, the effect of such a winding up order is worldwide. And then turning over the page, the crux can perhaps be seen at C. It would seriously handicap the efficient winding up of a British company in an increasingly globalised economy if the jurisdiction of the court responsible for the winding up of an insolvent company did not extend to people and corporate bodies resident overseas who'd been involved in the carrying on of the company's business. So well, that is what one might say, a clear example of where a statute, the purpose of a statute or the object of a statute can't be achieved without giving it extraterritorial effect. Again, we say very different from this Act when we come to look at it. A contract.
Yes, but you're depending time and again on on authorities concerned with extraterritorial effect in order to as providing the principle that's relevant to an issue to do with the overriding effect of a conflict of laws rule.
And Lord, to which my answer is, and I accept that because most of the authorities are authorities on extraterritorial effect related to conduct, but the reason I say that is the proper approach is that Cox and Ergo makes clear that one pulls them together, and indeed that is a choice of law case, Cox and Ergo, and in the extraterritorial effect context, of which Bilter and Nazir are an example, there is reference to the choice of law context. So the the assumption behind all these cases is that the rules are the same. I certainly accept the context may make it easier or harder to displace that presumption. That I certainly accept, that they are different. But the relevant question of is it expressly enacted or so plainly to be applied is, in my submission, the same question or test in both cases. And certainly none of the cases, if I turn it the other way around, none of the cases have suggested there is a difference, even if I accept that the justification is a different one.
Yeah, I mean, the way Lord Toulson and Lord Hodge dealt with it in paragraph 212 was to identify the relevant issue in the sixth line, roughly, as being it relates to whether the court can regulate the appellant's conduct abroad.
Yes.
Whether a court has such jurisdiction is a question, and then they go on to analyse how the case law has evolved into a question of interpreting the particular statute.
But the important point being that as part of that analysis, one of the cases that's part of that analysis is Cox, which is a choice of law case. So, but my submission, as I said, I accept that they raise different issues. My submission is that the cases to date, the authorities to date, suggest a common test, even if it may be easier or harder to disapply that test depending on context. And Lord, insofar as the question is, well, does the law need to develop further to indicate that they are properly separate concepts, Lord, I wouldn't stand in the way. I'd say that the appropriate...
Well, I think everybody would have regarded them as entirely separate concepts until Lord Sumption's judgment in Cox.
Well, with respect, it was the court's judgment, because Lord Sumption's judgment agreed to by...
You have to bear in mind also that, as a matter of precedent, we're bound by what the court decided in Cox. We're not bound by Lord Sumption's reasoning.
Lord, I'd accept that. But I think if one asks the question on the principle basis, one gets to the same answer, because ultimately what Lord Sumption was focusing on was to provide the answer in the context of a choice of law, a question of disapplying choice of law. So insofar as there is binding precedent, it is the process for the decision on choice of law, of which this case is one. But my submission is that what is identified there, namely principles that need to be, outcomes that need to be satisfied in order to justify an implication being sufficiently plain, are good ones, and that apply. In some ways, it might be said a fortiori in a choice of law concept where you actually have a competing policy, an English policy. I mean, in the extraterritorial cases, you have international law, comity, all important factors. But within the English context, you are balancing a choice of law rule, which would normally be regarded as applying, with a statute which is not expressly saying it shouldn't. And those, in my submission, raise similar issues, or if anything, one would say that the disapplication of the choice of law rule should be an even higher hurdle.
Is there any help anywhere, Mr. Doherty, about what Lord Sumption meant when he said in Cox that the presumption against extraterritorial application is more or less strong depending on the subject matter?
Well,
it's paragraph 27.
Yes. My Lord, I'm not sure whether we have the authorities in the bundle, but it's certainly right that in various authorities there is reference to presumptions being more or less strong, and indeed reference to, in some circumstances, there being no presumption at all. I think that's particularly in the context of where one is talking about a British subject outside the jurisdiction.
Yeah.
One can perhaps quibble which way round that should be, whether it should really be that the presumption is the same, but it's easier to displace depending on context. But it's certainly right that it will be easier to imply certain effect, to assume that is what Parliament intended in certain contexts than others. I mean, the torture cases, albeit they're dealt with expressly, are perhaps a good example where one can say there's a very clear imperative in international law as recognised by the British government to give effect to certain rights. And that may be a relatively easy one to assume how it should be applied. There are others where, of course, it may be more difficult to assume why the English court would be seeking to regulate theft overseas.
But your point is that, according to this case, there is such a presumption, and it applies to choice of law cases.
Yes, Maud.
That's the core, isn't it?
That's the core. I mean, your Lordship will have seen how we put it in our written case. I mean, we actually take it in stages. We say, even before you get to the presumption, you don't get to any implied effect. Before you get to the presumption, you've got a choice of law provision and you've got a statutory provision, which are potentially pointing in different directions. You've got to resolve them. So you've got an initial point of construction to do anyway. And then when you get to the presumption, we say it becomes increasingly obvious what the answer ought to be. Because one starts off with a proposition, which, as I started off my submissions by saying, which underlies choice of conflict of laws more generally, that you would expect to be applying choice of law unless there's good reason not to. My Lord, the second case I was going to refer to, as I said, was the KBR decision. And in that case, this court concluded that Section 2(3) of the Criminal Justice Act, which allows notices to be issued requiring production of documents under criminal sanction, it was not of extraterritorial effect. And as I said, I accept again, this is not a choice of law case. It relates to conduct outside the jurisdiction. I don't propose to take your lordships to the reasoning, because I'm not trying to argue by analogy with the KBR decision, but perhaps just to underline a few points that I made earlier about approach. If I can take your lordships to page 915 of the electronic bundle. At paragraph 27 of the judgment of my Lord Lloyd Jones. And this is under the heading, is the presumption rebutted by the language of the statute? And the answer given in the second sentence is, the answer will depend on the wording, purpose and context of the legislation considered in the light of the relevant principles and interpretation and principles of international law and comity. Now, obviously, the last bit doesn't apply, and I accept that. But the first bit I refer to simply to make clear that this isn't some alien approach to construction. One is approaching the question of the application of an act, and specifically the 1978 Act, on traditional principles subject to the presumption. So when one is looking at the Act, one is applying, in the normal way, wording, purpose and context, but one is considering, as a result of that analysis, whether one satisfies the requirements that Lord Sumption identified in Cox. And what those requirements represent are reasons as to why it must be intended that Parliament intended to space the law that would otherwise apply. And if one turns over at paragraph 28, my Lord Lloyd Jones considers the wording, considers that they're broad, but that doesn't answer the question. Paragraph 29, the consideration of the Act as a whole, which ultimately, and one sees that intention on the part of Parliament to give extraterritorial effect, may also be implied from the scheme, context and subject matter of the legislation. And then I'm unable to find a clear indication either for or against the extraterritorial effect. That's conclusion in that case. And then at paragraph 31, there is, however, greater force in the further submission on behalf of the SFO. It is clear that an intention to give a statute extraterritorial effect may be applied if the purpose of the legislation could not effectually be achieved without such effect. And that, again, is tying in the Cox analysis from the choice of law into the extraterritorial analysis. And then at paragraph 32, the question whether such a purposive reading is capable of rebutting the presumption against extraterritorial effect will depend on the provisions, purpose and context of the particular statute. And then it also requires consideration of the legislative history of the statute. But that's something I'll consider separately. So, Lord, the purpose for referring to the case was really just to underline that we're not departing from normal rules of construction, but where Cox fits in, and there is danger of looking at paragraph 29 as a sort of self-contained rules of construction for extraterritorial effect. No, it isn't. You do the normal rules. 29 is setting out what you need to have achieved. And Lord, I should say, I'm bound to be corrected now by saying this, but we're not aware of any case where any statute has in fact been found to implicitly override choice of law, but I'm sure someone will come up with an example. But our researchers haven't identified one which is relevant. So, Lord, if I may turn now to the Act, the 1978 Act, and that can be found at page 252 of the electronic bundle. And one sees that the Act provides that it is an act to make new provision for contribution between persons who are jointly or severally or both jointly and severally liable for the same damage, and in certain other similar cases where two or more persons have paid or may be required to pay compensation for the same damages, etc. If one then turns to page 254, one gets to section 1, entitlement to contribution, and Section 1.1 is the main operative provision in relation to contribution. Subject to the following provisions of this section, any person liable in respect of any damage suffered by another person may recover contribution from any other person liable in respect of the same damage, whether jointly with him or otherwise. And just then pointing out the provisions which have been relied on, Section 1.3, a person shall be liable to make contribution by virtue of subsection 1 above, notwithstanding that he ceased to be liable of the damage in respect of the damage in question since the time when the damage occurred, unless he ceased to be liable by virtue of the expiry of a limitation or prescription which extinguished the right on which the claim against him was based. And at one point it was suggested, well, there were no such English rights which had extinguished causes of action. Of course, that's not right. There is Consumer Protection Act, there's the conversion, Section 3 of the Limitation Act, which are in the bundle. So, my Lord, that is equally applicable whether one is referring to underlying English or foreign rights, contrary to, I think, the submission, I'm not sure it's still made, that it indicated somehow an intention to refer to foreign rights. Section 1.6 is the main provision that's been relied on by the Court of Appeal. So all the members of the Court of Appeal relied on 1.6, as did Mr. Justice Sewell. And what 1.6 does is to define what is meant by liability. And it makes clear that it does not matter if the underlying liability is based on a foreign law. So references in this section to a person's liability in respect of any damage are references to any such liability which has been or could be established in an action brought against him in England and Wales by on behalf of the person who suffered the damage, but it is immaterial whether any issue arising in any such action was or would be determined in accordance with the rules of private international law by reference to the law of a country outside England and Wales. Now, Lord, 1.6 has been considered in one context in a series of cases, and that is the reference to the question of what the words which has been or could be established in an action brought against him in England and Wales mean. Does that import some form of procedural hurdle? And in a number of decisions, in the cases of the Bernati judgment of Mr. Justice Hobhouse, Captain George's, the decision of Mr. Justice Hurst, and in the Baltic Flame, Court of Appeal judgment given by Lord Justice Potter, the courts have unanimously held that that provision does not import any procedural hurdle. It's a question of substantive liability. So in other words, the fact that you could not in fact bring a claim against the contribution defendant in England, it does not mean that it's not a claim which has been or could be established in an action in England and Wales. So, for example, that there is a jurisdiction clause in favour of another country or an arbitration clause with the contribution defendant, as between the contribution defendant and the main claimant, that doesn't prevent reliance on Section 1.6 for establishing the liability. There's no procedural hurdle.
Well, what's the significance of the words in that case?
Lord, the conclusion is that it's simply an emphasis on the substantive underlying liability. I mean, that is presumably, I mean, your Lordship's right, that and I think it's accepted by Mr. Justice Hobhouse, that you could literally read those words as importing such a procedural requirement, yeah. But that that would be contrary to the broad approach to liability generally and serve no useful purpose. And so the courts have consistently held, since the original decision of Mr. Justice Hobhouse, that there is no procedural hurdle.
Well, it might be read as implying essentially that this provision is concerned with actions in England or at any rate actions which could have been brought in England.
Yes, Lord. The arguments that were run was that it did imply some form of procedural hurdle, i.e. you had to be able to bring the case in England, and indeed a time hurdle, that you had to be able to bring it at the time that you brought the contribution claim. I mean, both of those were rejected by Mr. Justice Hobhouse as not fitting with the scheme of the Act. I can give your Lordship the references if your Lordship wants. So in the Bernati...
but obviously one can't establish a scheme of the Act without regard to these words. Oh,
my Lord, I agree. One obviously has to look at the entire Act. I should say so in the Bernati, just for your Lordship's note, yep. The relevant section starts at 462 of the electronic bundle onwards. Perhaps I should just take your Lordship to it, because obviously it is the main authority on 1.6, albeit it's not quite on point, and I know my learned friend relies on for a slightly different point, so I will take your Lordships to it. If your Lordship could turn to page 462. And if one starts at H, the Act is drafted on the basis that the word liability is used potentially in the widest possible sense and can, where it's proper to do so, take into account the provisions of foreign legal systems as well as those of the legal system of England and Wales. Thus, where a party who is claiming the contribution can show that under English conflict law rules reference should be had to some foreign legal system, he can rely on that system, and where the person responding to such a claim can show that under an appropriate foreign legal system he would be entitled to a limit or reduction of liability, he can still do so, providing it corresponds to a limit or reduction available under English law. And then he turns to E. I now turn to the problem of construction of section 1.6. And he then says that you don't get anything from the Law Commission report on 1.6, which is right. On the specific wording of 1.6, you don't get anything from the Law Commission. That was added in by the parliamentary draftsman. And then one sees under F the submission that's made. The starting point of the Charter of Submission before me was that section 1.6 imposes a procedural as well as substantive criterion. They argued that words could be established in an action brought against him in England and Wales, denote an entitlement to bring such proceedings in England and Wales, even if such proceedings has not yet been brought. And then perhaps one can jump to the final paragraph on that page. I consider the Charter of submissions are mistaken. Section 1.6 of the Act is concerned with providing a definition of or guidance about what liabilities may be taken into account for the purpose of Section 1. I consider the section is concerned with the character of the liability and not with any merely procedural considerations as to how it might be enforced. As it was put admittedly obiter, by Sir John Donaldson, Marshal of the Rolls, and Logan and Uttlesford, subsection 6 merely provides that the test of liability is to be applied by reference to such liability as could be established before court in England and Wales, irrespective of what substantive law that court would apply. I do not consider that section 1.6 is concerned with such problems as to whether or not the writ could have been served out of the jurisdiction. Such considerations are alien to the substantive scheme that is provided by the Civil Liability Contribution Act and would serve no purpose relevant to the scheme of the Act which I am able to discern. If the respondent to the contribution claim is, as here, a foreigner, then before such a foreigner can be made subject to contribution claim, must establish some procedural right under RSC Order 11, which entitle him, the claimant, to proceed. If he cannot establish such a right, a procedural entitlement, no question of liability under the Act will arise. If he can, there is no need to apply any further inquiry and the provisions of the Act should be applied. It continues, and he deals with the question of timing at page 465 under B as well. So, I mean, that's the part of the Act that's been considered. It's been repeatedly considered as not imposing any form of substantive hurdle in relation to the operation of the Act. So, if I can turn back to the 1978 Act and section 1.6 on page 254. The short point we've made, and your Lordships will have this obviously from our written case, is that there is nothing in section 1.6 that tells you whether you are displacing the choice of law. Section 1.6 makes sense whether one considers the Act to have overriding effect or not. In either case, you need to determine what liabilities the Act applies to. If the Act is to have overriding effect, you still need to know whether the Act extends in application to foreign liabilities. Similarly, if it doesn't have overriding effect, you need to know where English law applies, such that the 1978 Act applies, which liabilities are you to take into account? And section 1.6 spells that out. Lord, if one took out section 1.6, and in fact the Law Commissions, you will see, didn't originally have section 1.6, in my submission one would almost certainly have come to the same conclusion, that actually liabilities means the underlying liabilities, not an English liability. But what section 1.6 does is to make that entirely clear. And indeed, it's a point that Mr. Justice Hurst makes in the Captain Georges. Section 1.6 is useful because it spells it out.
Are you going to come to section 2.3?
Oh, yes, Lord. I will.
I'm not suggesting you.
No, Lord. Because, I mean, section 1.6 and 2.3, in one sense, are very similar because they both recognise that there is private international law in the background. And so that they both do. But they are both necessary.
They're also similar in that they both contemplate an action brought in England and Wales.
Yes, Lord. So, of course, for present purposes, what we say is relevant is that the Act needs to provide for the position of foreign liabilities. Either way. I mean, the conclusion could have been one ignores them and you can't get contribution for them, or you include them. But that decision, whether you include them or you don't include them, is equally consistent with whether it has overriding effect or not. That's the point. Lord Justice David Richards accepted the principle that it might be said that Section 1.6 really only applies if the choice of law is English law, and he accepted the principle. The point was
that's the alternative, isn't it? It's either overriding effect or it only applies where you're applying English.
Precisely, which is my submission. That for all these.
So then the question becomes, what cases might there be?
Precisely, and what Lord Justice David Richards said was that whilst he accepted that there was that theoretical possibility, he thought that it was small to the point of invisibility that that English law would apply if you had two, and he gave the example of two tortfeasors subject to foreign law. And the point being, well, if you're catering for that possibility, that suggests that you are really catering for a position where otherwise it would be subject to foreign law, therefore you're implicitly pointing to English law applying as a matter of overriding effect, or the Act applying as a matter of overriding effect. In my submission, there are a number of difficulties with that. I mean, first, the premise of the assumption isn't, we'd say, particularly helpful. Two tortfeasors subject to foreign law. Well, I mean, that's one example, but of course, the Act covers the multiplicity of contract tort. There could be dozens of tortfeasors or parties responsible, whether under contract tort, other wrongs, subject to different laws. And testing it by reference to the most extreme example doesn't necessarily help in analysing the intended scope of the Act. But in any event, the Act still needs to deal with it. It would be an obvious lacuna to say, well, it's unlikely that English law would apply in a situation where you have an accident in France and it's the underlying claims are subject to French tort. But were they to do so, you need to have an answer as to what happens. You're not going to create some long schedule of examples saying, well, if it's so obvious, we don't need to deal with it. You have a simple provision which simply says, this Act deals with foreign cases. It doesn't deal with choice of law at all. The second difficulty...
Can I ask you, in Section 1.1, the reference to any person liable must, I think, or would you agree, mean any person liable in damages?
I think there's some law about this, which I hesitate to say something which might not be quite right, because there is obviously the case law about the distinction here between damage and damages.
Absolutely.
And so I hesitate to...
Just as a matter,
yes.
As a matter of ordinary English, at the moment it looks to me as if you couldn't possibly recover contribution unless you've been found liable in damages.
Well, the word found isn't liable there. I mean, the issue is liable in damages rather than found liable.
Or, if you like. Well, can you recover contribution if you simply because you are abstractly liable?
Well, I think, again, that's another interesting question which your lordships don't need to answer.
Restitution.
There is the question...
It's got to be money, hasn't it?
Well,
no question of contribution.
Well, Lord, I think there may be different questions. That you clearly aren't going to recover anything. The question is when, in a way, the cause of action, which is separate here from the potential of when limitation starts, arises. Of course, as your lordships are aware, it's common to bring a contribution claim before you've actually paid any money out. And I don't think one would suggest, well, that actually there isn't a cause of action. The analysis is probably Section 1 gives you the cause of action. There is a separate time limit for limitation to run, which is specifically judgment or when the damages have been assessed. And so one could tie those together.
But liability in respect of any damage surely must be a liability in damages.
Yes, well, as I said, I'm cautious here. Because
I'll tell you what the chain of thought that's going through my mind is. If 1.1 is talking about liability and damages, then 1.6 is talking about a liability and damages which could be established, has been or could be established in an English action. So, for example, if somebody had been found liable in California by a Californian jury to some colossal award, then that wouldn't be a liability which could have been established in an action brought in England and Wales. And if one goes on to 2.3, if I can bring that up. Yes, because otherwise 2.3 doesn't really make sense, because it caps damages by reference to English statutory limitations or contributory negligence. But it scarcely makes sense to sort of strain at a statutory limitation, but swallow the possibility of American juries awarding umpteen millions.
I may be missing your Lordship's point, but that probably wouldn't arise anyway, because of course what one's referring to here under 1.6, and I would accept, is the liability that could be substantively established in England. So if it's not a liability that could be substantively established under the English private international law rules, it doesn't count for the purposes of 1.6 anyway.
So when you say substantive, are you talking about...
The relevant... Your Lordship, as I understand, is positing an example where there is a judgment in the US. 1.6 is not dealing with that situation. 1.6 is asking a different question. Could you establish that liability in England, subject to private international law? And if you can, then 1.6 applies. There's obviously a separate question as to the status of that foreign judgment. But that's alien from 1.6. Yeah. Because 1.5 is dealing with UK judgments. There was, in fact, a section 2 of the bill that was, which in fact dealt with foreign judgments, which was excluded. Because it was drawn back to the Law Commission's original proposals. Yeah. But I'm not sure whether it assists in my submission on
it would if what's going through my mind is simply whether 1.6 is really an indication that this is a provision that's concerned with either English actions or liabilities that could have been established in England. In which case, well, obviously, the Californian, the hypothesis of a settlement or an award in California is one step away from an award or a settlement in Germany.
Yes, but of course, what we're comparing here is, as I said, we're not considering foreign awards or foreign judgments. We're considering whether, when a claim is brought in England, one should be considering the German law of contribution, such that it is said that 1.6 is implicitly ousting the choice of law rule, which would have pointed to German law, to say, well, because there's a reference to choice of law in 1.6, it can't intend that to apply to. It must be intended to exclude the operation of the choice of law rules, and one doesn't get to that in my submission.
Well, 1.6, unless I'm reading it wrong, which I may very well be, defines, doesn't it, the expression a person's liability in respect of any damage, which is the expression that you start with in 1.1.
Yes. Yeah. Exactly. It's defining the liability.
We're only interested in liability in respect of any damage which could be established in this country.
Yes.
Assuming and not worrying about any procedural difficulties of getting the defendant here. Yes.
So it's recognising that if the claim were brought here, what would English conflict of law rules point to in terms of the applicable law? And that might be and if that happens to be a foreign law, you take into account that foreign law in accordance with English private international law rules. But that isn't telling you. But that's a question that is relevant under either analysis. And that in my submission, is the core point here. Is however much one dissects 1.6, the answer to 1.6 is relevant under either consideration. I mean, we put it in the written case. So, if you put in at the front of this act has overriding effects, or clause 1, or clause 2, this act is subject to choice of law, section 1.6 would be equally relevant under either analysis. Because under either analysis, you would need to provide an answer of what you would do where the underlying liability, in accordance with English private international law, is in fact not English law. Do you take into account, or are they excluded from the scope of the Act?
Yes. I mean, and it's only defining liability in relation to the claimant, and no more.
As between claimant and the contribution defendants, the two sides of the triangle, yes.
Yes, it's saying nothing in itself about contribution.
Nothing at all about the contribution right. Quite right. And just finishing off the point of Lord Justice David Richards, who accepted the principle but said it's vanishingly small. Well, as I said, I made the first point that the premise of the assumption isn't actually particularly helpful, because there's a whole range of cases that one may have, and testing it at its most extreme doesn't really alter the fact that you need to cater for all situations.
Give us some examples, will you, Mr. Doherty?
Well, because the first question is whether it's a useful question. The second question is, well, is it in fact right?
Yeah.
And in my submission, it's not right. I mean, and the examples that one can give, certainly at the time that the Act was given, so one's looking at what the law most closely connected to the choice, to the contribution claim is, or the restitutionary right, one would be looking at, for example, existing contractual or family rights, family relationships between the contribution parties. So if, for example, there is a mother and father are responsible for, or husband and wife are responsible for an accident in France, and they are both liable under French law to the claimant, it may well be said that the question of contribution as between husband and wife, because of the pre-existing relationship, is most appropriately regarded as being a matter of English law.
I did?
Because of the family, well, because of the family relationship. The examples of that in the tort examples, that, for example, there was, the Edmonds and Simmons cases, the bubble cases, where the courts concluded that actually there was really no foreign element in relation to the relevant relationship, and that English law was the more appropriate law to apply to that effectively bubble. And so one might say between the contribution defendants, claimant and defendants, if they have an existing relationship, that may be the more appropriate law.
If the right to contribution arises out of not the fact of the accident, but their family relationship. It's not so much that it arises out of the family relationship. It's the fact that what law is most closely connected to that question, and it might be said that it's their relationship that provides the key point. Similarly, if you're right, Mr. Doyle, I just can't see I can't see what facts might give rise to it. What's happened? It's not a car accident. So, Lord, I suppose if you have husband and wife in France, and they are both liable in tort for whatever reason, for some accident that's befallen. They can't both be driving, but some accident that's befallen. Allegedly responsible for not having supervised the playing equipment or whatever it is, as against a French claimant. The liability to the French claimant would presumably be under French law. The relevant liabilities as between themselves may be regarded, I don't think it's higher than this, might be regarded as being more appropriately subject to English law. Similarly, if there is a pre-existing relationship between contracting parties, which doesn't cover the question directly, because obviously then there's simply a contractual claim, it might be said that that relationship is more closely connected to the contract. And Lord, if one looks at the dicey provisions on restitutionary claims, one sees that, for example, if there's an existing contractual right, the restitutionary claim may be regarded as being more appropriately connected to the contractual claim. Other examples, of course, may be the ones that this court considered in Brownlee too, in relation to where a party simply chooses not to plead a foreign law. And so the default rule is applied. How can that confer
Well, obviously the application of the default rule is simply that you apply English law. So that would be a case where you simply apply English law.
Well, the default rule, you're not applying English law, are you? You're applying foreign law, but treating its content as identical to English.
Well, Lord, I think that's the presumption of similarity. As I understand it, the Lord Legate's judgment is to draw the distinction between the default rule, where you simply apply English law, and the presumption of similarity, which is where you haven't pleaded a certain or proved a certain aspect of the foreign law, in which case it's presumed to be the same. Now, but I mean, they're all examples of where you can have a situation where the English court is in fact considering this by reference to English law. And of course, this is all in a context of where often one doesn't actually plead and prove a foreign law. I mean, as your lordships will be aware, this is a point I'll come on to later, you only plead and prove foreign laws where there's a material difference. If there's not thought to be a material difference, you simply proceed on the basis of English law, typically. In this case, the only difference is between German law and English law, which is relevant, is limitation. So, Lord, those are the reasons that we say that the approach that Lord Justice David Richards says is not right. I mean, I said, for the premise of the assumptions, well, there are a whole variety of assumptions with multiple parties, multiple laws that can arise. And the rule has to be simple and provide an answer in each case. You can have situations where, even if they're underlying foreign, if the underlying torts are foreign, English law might apply, as I said, pre-existing relationship, contractual relationship, indeed agreement of the parties. And finally, one has the default rule on pleading. So all of those are examples of why we say Section 1.6 doesn't show you anything. And that's before we say you get to the presumption. This is just on ordinary construction without the benefit of the construction. Lord, Section 2.3 of the Act is a provision that the Court of Appeal didn't find provided any extra assistance. It was confirmatory of the point made in 1.6. And again, Lord, it's the same point. Whether it is overriding or not overriding, a Contribution Act needs to determine and set out the extent to which the assessment is to vary by reference to the foreign law. And unsurprisingly, the conclusion set out in Section 2.3 C is that you take into account any corresponding limit under foreign law. As with Section 1.6, my submission is that if you took out 1.6 and 2.3c, the courts would probably have reached exactly the same conclusion in any event. Liability is most naturally to be understood as the relevant liability in English, however arrived at. Lord, finally, can I take your lordships to Section 7.3? This was a provision which the majority in the Court of Appeal relied on heavily, and indeed appeared to be the key point for Lord Justice Irwin, but which Lord Justice David Richards didn't think assisted either way. Now, 7.3 provides the right to recover contribution in accordance with Section 1 supersedes any right other than an express contractual right to recover contribution, as distinct from indemnity, otherwise than under this Act in corresponding circumstances. But nothing in this Act shall affect an express or implied contractual or other right to indemnity, an express contractual provision regulating or excluding contribution, which would be enforceable apart from this Act. Lord, the point is very similar. We say it presupposes that Section 1 applies, i.e. Section 7.3 begs the question at issue. Is this Act overriding or not? Now, Lord Justice Irwin raised the question, and it had been raised in the Court of Appeal. Well, what sort of rights could these refer to? It must refer to foreign rights, mustn't it? But as Lord Justice David Richards pointed out, there are, of course, plenty of rights which were superseded as a matter of English law, for example, rights between directors, trustees, which were being referred to. And that's a point, I won't take you to it, but which Professor Mitchell makes in some of his articles on the Act. The references are page 1236 and 1305, which refer to the other types of Act that are relevant. So, Lord, we do say, Lord Justice David Richards is entirely right to say that Section 7.3 doesn't take you anywhere. First, because it begs the very question as to it's only really applicable where Section 1 applies. Well, does Section 1 apply? And secondly, when it refers to rights, it is most obviously referring to the existing common law rights. It's not purporting to talk about foreign rights. And that's supported when one looks at the legislative context, which I will come to later. The other point just to make on Section 7.3, in a context where it's suggested that the Act has some form of policy imperative behind it, is to note that it is an unpromising candidate for mandatory effect, that it can be disapplied by agreement. So Section 7.3 makes clear that it doesn't affect an express contractual provision regulating or excluding contribution. Well, we say, well, that is inconsistent with the notion of treating the Act as having some policy imperative which should be applied in any event. So, Lord, if one stands back from the Act and one says, well, does the Act make express provision? Well, no. On no analysis can it be said to make express provision to say that it applied irrespective of choice of law. And there are good examples in the statute book of what express provision means. And the one we refer to in our written case is Section 27 of the Unfair Contract Terms Act. That's at page 247, in fact, a contemporary act of the 1978 Act. I think we give an example of the 2010 private international, the 2010 Third-Party Rights Against Insurers Act as well, for a more recent example. But there are plenty of examples of it. It's a well-known parliamentary technique, and it's not been adopted. And in terms of implication, one simply can't say one way or the other from the provisions relied on, 1.6, 2.3 or 7.3, whether it is intended to have extraterritorial or overriding effect. As I've indicated earlier, if you test it by putting in an express term to either effect, they stand. And you would need to make provision. Both are equally consistent. So there's nothing in the wording or the scheme of the Act, in my submission, that points you for some form of implied effect. And that becomes all the more obvious, in my submission, when one factors in the presumption. Now, Lord, the Court of Appeal, as I've indicated earlier, started with the Act and really only dealt with the presumption at the end. And indeed, in my submission, the error in the approach is perhaps most obvious where Lord Justice Irwin, and this is, I'll just give your Lordship the reference, but paragraph 63, page 103, says it would have been simplicity itself to include a provision saying that a choice of law applied. Well, Lord, that's not just to ignore the presumption, it's to reverse it. And Lord, if one works through the guidance in Cox, knowing that one's looking at the wording, the scheme, the context of the Act, there's nothing in the terms of the Act that mean that it cannot be effectually applied if it's confined to cases where English law applied. Indeed, that was accepted by the Court of Appeal and by my learned friend. In relation to the purpose of the Act being effectually applied, again, there's nothing about the purpose that requires it to apply to foreign claims. Now, we'll look at the Law Commission report and it's clear that wasn't part of what they were recommending, but quite apart from looking at that, from the Act itself, there is nothing implicit in the Act that it needs to displace the foreign law. Now, in the Court of Appeal, Lord Justice Irwin identified as a purpose, and this is at paragraph 64 of the judgment, the simplification and standardisation of the law. It's not entirely clear where that purpose came from, and I'm sure most draftsmen would like to think that they're simplifying and standardising the law, but it certainly was a simpler statute than the 1935 Act. It was a wider statute, and one can see that it might have been standardising, but where that purpose came from the scheme of the Act is with respect unclear. But even if that is the purpose to be derived, that simply doesn't extend to saying that it should be a standardisation of the rules that apply in relation to foreign law rules of contribution. Simply, there's nothing in the scheme of the Act to indicate that that was intended, let alone plainly intended. My learned friend refers to the policy or purpose of the Act in his written case as a recognition of the justice of having a comprehensive rights of contribution before the English courts. And again, the rhetorical question is, where does that come from? Why? Of course, it's always right that it would be easier to ignore choice of law altogether. In any tort case or contract case, if one just applied English law, there would undoubtedly be simplification. But of course, it would run counter to the very purpose of conflict of laws and the justification for conflict of laws, which is that the justice is to be found in connecting cases with foreign elements with the systems of law to which they're most connected. So, Lord, we say that there's no ground there. Now, Mr. Justice Chadwick and Mr. Justice Sewell had a slightly broader policy ground, which was to identify that there would be a defect, or a serious defect, as it was put, if no right of contribution were available as a matter of, in a case where two parties were before the English court. But again, that's not an injustice, that's a potential, and I say potential only, a potential consequence of applying the choice of law. Applying a foreign contract or tort claim may mean that a claimant does better or worse than they would do in England. That's a consequence of applying the choice of law. It is not a defect. So, in that regard, Lord Justice David Richards was entirely right in his judgment to say that the criterion simply couldn't be fulfilled in this case. And we say that there's simply no coherent or principled reason from the scheme or wording of the Act to assume that Parliament intended to override what would otherwise be in the choice of law. And the obvious policy imperative would in fact be to apply the choice of law, because that is what best reflects the legitimate expectations of the parties, and doing justice between the parties in a case with foreign elements. Now, Lord, we say that's sufficient to answer the question. One doesn't need to go further into the legislative history, but if one does delve into the dark arts of legislative history, in fact, what one finds is the position is confirmed. Now, it's right to set the context here and to understand the purpose. To understand the purpose of the 1978 Act, one has to consider the previous law. And the law as it stood before the 1978 Act was the curiously named 1935 Act, which was the Law Reform Married Women and Tortfeasors Act, which was restricted to tort. And one can see that's at page 221 of the bundle, section 6, 1C. Now, the important point for this part of the argument is to understand the assumed position as it stood prior to the enactment of the 1978 Act. And the position as it stood prior to the 1978 Act was that the leading commentators assumed that contribution was subject to choice of law. And I can make that good by two short references. If I can first take you to an extract from Professor Glanville Williams's book on contributory negligence, but also, which also dealt with contribution, which is at electronic page 1080. It's a book that Professor Mitchell, who's probably the leading modern commentator, described as still the best exposition of the law in the area. And if one turns to page 1082, and I should say this is a book first published in 1951, but continued getting impressions up until 1977. Paragraph 39, contribution under the conflict of laws. The Tortfeasors Act allows the recovery of contribution between parties liable in respect of damage. Literally speaking, it is possible for parties to be liable under a foreign system of law. This does not mean, however, that the Act is capable of being applied indiscriminately to liability for foreign torts. If 3 Ruritanians are involved in tort litigation in Ruritania, under whose law there is no right of contribution, it is inconceivable that merely by coming to England and suing here, they could obtain the benefit of the Tortfeasors Act. A converse situation is when the English courts will enforce a right of contribution arising under a foreign law. It is clear that both of these questions, the scope of the English Act and the effect to be given to foreign systems, should be answered on the same principle, but on what principle there is little authority. It is submitted that the matter in issue is not one of procedure, governed by the Lex Fori, but is substantive law arising ex lege. Whether it is called quasi-contractual or a statute claim makes no difference. And then he analyses what the choice of law rule, whether it should be the lex loci delicti or the quasi-contractual rule, which isn't relevant. But the assumption that's certainly being put is that it should be subject to the choice of law. And that's a point that was being made by the editors of Dicey and Morris right up until the 1978 Act. And one can see that from the 9th edition of Dicey and Morris, which one can find at page 1087. This was the edition published in 1973. And the relevant section starts at 1089. Again, makes the point there's no authority, but it says, contribution and indemnity. There does not appear to be any English authority on the questions of what law governs the right of one tortfeasor to claim contribution or indemnity from another. If the right to contribution is statutory, as it is in English domestic law, it is submitted, contrary to the submission in the previous edition of this book, that an English court would characterise it as quasi-contractual and not as delictual, and would therefore apply the proper law of the obligation in accordance with Rule 176. So that was the context in which, if anyone had looked up, well, what's the conflict of laws position in relation to contribution prior to the 1978 Act coming into place. And one turns then to look at
Professor Morris. We haven't got to Dr. Collins yet.
This is pre yes. Dr. Collins or Lord Collins, yes.
Thank you.
Lord, one can then turn to the Law Commission report on the on contribution, and obviously it's uncontroversial that one's entitled to look at the Law Commission report in order to identify the mischief and purpose of any legislation that's derived from it, and I'm obviously here slightly establishing a negative, so I'll take this quite briefly, because, of course, there's nothing about conflict of laws in the report.
Well, the trouble is that they didn't have 1/6, did they?
Well, they didn't have 1/6, and I'm going to come to that. Okay. But you're quite right. They didn't have 1/6, and they didn't have 2/3. And there are a few other provisions they didn't have as well. But, Lord, if one turns to the report at page 957... And at page 960, one can see who the commissioners are. They included Dr. Peter North. And then at 963, it sets out the core of the purpose of the work. And that obviously, as one is aware, there were a number of things that the Act changed, but the key one was expanding the scope of the wrongs for which contribution could be claimed. But if one turns to 985, the recommendations, paragraph 81, one sees there the conclusions of the Law Commission, and it's...
Sorry, page...
Sorry, my lord, 985.
985, thank you.
Paragraph 81.
Do you mean that? Oh, sorry, yes.
And on that page and the following page, it sets out the recommendations, each of which ultimately found its way into the Act. Now, it's right to say some of them were slightly modified as they made their way, but the actual recommendations themselves found their way into the Act. And insofar as of interest, I can give your lordships where they find their way into the Act on each of them, but perhaps I'll come back to that if anyone has interest. Otherwise, I'll. But the point is, subject to playing around with the drafting, that they all found their way into the Act. So there's nothing about private international law or overriding effect in the Act. There's no indication that any part of the mischief or problem in the previous law is regarded as the choice of law issue or what law should apply. Simply not something to which the Law Commission is turning its mind as being a problem. And so, at that point, certainly, there's infertile ground to suggest that there was any intention to displace choice of law for what was a Law Commission bill. Now, the point that's made is that the 1978 Act looked very different from the draft bill which the Law Commission appended. And if one turns, my lord, to page 991 and following, one finds that this was one of those examples where the Law Commission had actually drafted a bill, which they sometimes do, and it's right to say that what was presented to Parliament was not based on it. I mean, they started again. And so that's an entirely fair point. But what that submission entirely ignores in my submission is that it's still a Law Commission bill. And as we'll see from... Sorry, let me put that slightly differently. That the bill that was put forward for Parliament still came from the recommendations of the Law Commission. And so the changes were changes of drafting. Yes, there were additions, but what they did not represent was a change of any substantive change. Now, Lord, we can see the bill introduced to Parliament, and I just show your lordships this quickly, so lordships can understand what's being referred to in some of the minutes of the committee that I was going to refer your lordships to. If you turn to page 1020, the bill is introduced. Your lordships can see the explanatory memorandum, and it's described as being this bill gives effect with certain modifications to the Law Commission's report and contribution. The bill will apply to England and Wales and to Northern Ireland. And then there's a short description. And if one turns to the bill itself, which starts at page, or the text of the bill itself, on 1023, one can see a bill that looks in very similar terms to the one that was ultimately enacted, albeit with some material differences. So, for example, Section 1 at that stage had 7 subsections. Subsection 1.5 ultimately disappeared, was deleted. The reference to private international law has already been included at that stage. And section 2, effective external judgments and awards, has been entirely deleted. And we'll see later that the reason why it's been deleted is because it's agreed that it should be cut back to the Law Commission's recommendation. So that was the one substantive example of where the bill had gone beyond what the Law Commission had recommended, and the effect of what was done in committee was to remove the sections that went beyond what the Law Commission had proposed. And the other thing that your Lordships won't see in this draft bill is an equivalent of section 7.3, because that was added as well. And if we turn to the work in committee, and if we can turn to page 1035, we see here first sitting of Standing Committee, Civil Liability Contribution Bill. And the promoter of the bill, for reference, is Mr. Patty, Mr. Geoffrey Patty, MP. And if perhaps one turns to page 1038, I just provide context. I'm not relying on this for interpretation, but just to understand what's going on. Under clause 1, there is an initial query raised as to why the wording has changed from what the Law Commission has proposed in its draft bill, and which is raised by Mr. Percival, and one sees the response of Mr. Patty at 1040, second column, second paragraph. As my honourable learned friend said, the bill seeks to give effect by some of the changes to which my learned and honourable friend has rightly drawn our attention to the recommendations contained in the Law Commission's report on contribution. One then turns the page to 1043. And this is all in the context of the reference to sections 1.2 and 1.3, because a point that's being made is that those express provisions weren't in the Law Commission's bill. And I think I can fairly summarise the point that's being made is, well, they simply spell out what the Law Commission intended. And indeed, that point is made by the Parliamentary Secretary to the Law Officers at page 1043 on the left-hand side. Second paragraph. I was about to adopt the argument of the Honourable Learned Member for Runcorn, except for his final conclusion. He was right when he said the bill spells out what the Law Commission recommended and does so more explicitly. So that's the context in which, and one will find repeatedly in the minutes, that reference to the Law Commission's intentions. What we won't find is any suggestion of an expansion on private international law of overriding effect. If one then turns to the 1045, again from the promoter of the bill, it's again addressing the same point. I do not think this case of a major change in law being slipped through humble measure being considered an eminent gathering. This is an attempt to give effect to what the Law Commission's report recommended.
Well, he goes back to that time without number, but he prefaces everything he says by saying he's rather reluctant to be dealing with it at all in the company of rather a lot of lawyers, who included some who would certainly have had a good deal of conflict of law experience and some who perhaps had experience in other fields. Yes, well, that's right. I mean, one of the things that also comes out from this is the close consultation with the Law Commission, including Professor North, in relation to things. I mean, so it's quite clear this was collaborative. Now, again, I don't need to rely on any of that. There's a negative and a positive point. The negative point is there's nothing in committee to suggest that there was any sea change from the Law Commission to include
an intention for overriding effect. And there's a positive point that I'm going to come on in relation to 7.3.
I see that in the draft, in the bill, clause 2 addressed liabilities established in foreign proceedings.
Yes, Lord, which was deleted.
Yes, and clause 2 enabled a person ordered to pay compensation in respect of damage by any non-UK judgment, read short, to recover contribution in accordance with Section 1. Now, you say that was taken out.
Yes, well, so
do we have an I mean, that's obviously our...
Yes, and obviously
that's effectively our case.
Your Lordship knows it's been taken out because it's not there, but I can take your Lordship to where it was taken out.
Yeah.
And of course, again, Lord, I don't want to spend time arguing about something which isn't in the bill. In fact, if it had been in the bill, it wouldn't actually have changed the argument at all, because you'd still have had the argument of saying, well, you still need to deal, whether it's overriding or not overriding, with what is the effect of foreign judgment. And indeed, that is a question that actually remains unanswered to this day, and where there might have been some argument for making it more express provision. But because whether you say the Act only applies where the Act has overriding effect, or where there's choice of law, you still have the question of what character you should give foreign judgments. And this bill, as passed, the Act didn't deal with it. But yes, if one goes to the second sitting, my Lord, which starts at page 1063, and one goes to 1068, headed clause 2. You have Mr. Patty there saying, I wish to say only that the discussions on the bill have indicated that it would be sensible at this stage for clause 2 be deleted. I say that to members of the committee who have not been part of discussions, etc. He will have read the Law Commission's report and draft bill, and he will have noticed that my bill goes further than the Law Commission intended to go. The price of last week's debate and the subsequent consultation has been to trim the bill back to the Law Commission's original proposals, and therefore it becomes necessary for us not to agree to clause 2. And Lord, obviously I rely on that in indicating again, the whole thrust of this was, if not to use the wording of the draft bill and annexed to the Law Commission's report, was to seek to implement, with obviously various amendments and modifications and clarifications of words, the recommendations of the Law Commission.
Yeah. So, I mean, clause 2 having come out, do you say that section 1 nevertheless covers foreign awards?
No, but I don't. I mean, there is a lively debate as to whether it does or doesn't, which I wouldn't propose to enter into. Clearly, clause 1 expressly covers certain forms of UK judgments beyond English judgments. I think that's clause 1.5. Yeah. The position in relation to foreign judgments, for example, which have been turned into English judgments, is a more complex one. What I would say is it doesn't matter. It's the point I made before, because whether it is overriding or not, those are still questions that arise, whether it applies to all cases, irrespective of choice of law, or whether it's only applying to those cases where the contribution right is subject to English law. There's nothing inconsistent with saying that there is a foreign judgment and the contribution right is an English contribution right as a matter of choice of law.
I'm sorry, I'm a little puzzled at the moment. I mean, we're concerned here, aren't we, with a liability which is thought to be established in German proceedings? No, Lord. Are we not?
No, Lord. We're concerned here with a liability that would be governed by the question whether that liability can be established in England subject to private international law. So if there's no choice of law rule...
I'm not talking about liability between the parties to the appeal, but the liability is thought to be established against the MOD in Right. Am I misremembering?
Yes, well, there's no German judgment.
No, I know that.
No, this was a claim made in England against the MOD.
Exactly, and we are being brought in.
And you say that Section 1.6 requires the application of German, is effective if German law is applied, but non-constant, that applies to the right of contribution.
Precisely.
You say 1.6, 2.3 and 7.3 are in effect neutral because they apply whether you're right or whether...
Yes. Well, it's more than just that they apply. It's that you need that same question needs answering.
Yes.
Whichever you do. That's the key point.
Regardless. Yes.
Because I can understand the point being said. Well, yes, you're raising theoretical points, but isn't it more likely? Therefore, it's a pointer. No. Yeah. That question still needs to be answered. Yes. And as I said, if one took out 1.6 and 2.3c, the courts would have had to have come to their own conclusion as to the scope of liability.
Thank you. I was misremembering.
I'm sorry, Lord.
But Clause 2, had it stood, would have given an English right to contribution in respect of the judgment of a foreign court, wouldn't it?
Under the 35 Act?
No, under Clause 2 of this...
Oh, sorry, under Clause 2. Yes, well, I mean, Clause 2...
That would have been a genuine case of overriding effect, would it?
Well, no, Lord, again, you'd still have the separate question, which you still need to answer, even under the judgments, because that question is again a question that really arises whether it's overriding or not overriding.
Well, no, because you'd be imposing an English rule of contribution on, or rather affording an English right to contribution to a person who had been a defendant to a foreign judgment.
Yes, Lord, this may be my reading of it, but I'm not sure it actually... what it doesn't do is answer that initial question of whether that right of contribution itself arises irrespective of choice of law. That's the point. That same question.
You mean whether the choice of law rules then apply to what kind of contribution rules you apply?
Precisely. So, I mean, as I said, fortunately, it's not one we have to worry about. But I mean, that's simply, you still have that question. I mean, I'm sure my submissions would be different, but the essential point would remain. But we don't deal with Section 2 because obviously Section 2 was... And of course, the important point about Section 2 going is it was taken away in order to take us back to the Law Commission. That's expressly what the promoter of the bill is saying.
I understand. Yes. But it would have been, surely, a clear example of an overriding rule.
Well, may I come back to that? Because I'm conscious that I want to get the wording right before I say something which isn't quite right. But my initial answer to that is no, it still doesn't quite answer that question. I understand why your Lordship says it may be different, but the wording of my submission is still not quite clear on that.
I mean, your big points are, firstly, that the Law Commission did not see this conflict of law question as part of the mischief. And secondly, that the three provisions relied on by the courts below were necessary, whatever the answer is to the question that we're debating.
Yes.
Yes. And whether Hansard adds very much, or whether Lord Hoffman's criticisms of reliance on Hansard, we can leave sticking to the wall.
Well, Lord, yes, and there's the final point I'm going to take from the minutes is really on 7.3, which perhaps is more specific because it explains why 7.3 went in, and it is entirely consistent with what Lord Justice David Richard says and what our submission is as to what it was intended to do. And that's at page, I said, 1067. And we can see there the amendment to add in what becomes 7.3 on the left-hand column at the top. And then the promoter of the bill, the amendments are designed to collect together two provisions in the bill about indemnity. We wish to ensure that all indemnity is left untouched by the bill. The aim is to make fresh provisions on the relationship between the bill and existing common law rights to contribution, between the bill and expressed contractual provisions concerning contribution, and finally to drop an unnecessary provision concerning the criminal law. So, Lord, we do say that, which is the explanation for the introduction of 7.3, is inconsistent with 7.3 having any intention for overriding effect. The reference there is to common law rights. And, Lord, bill went to the House of Lords, and at 1075, we can see it being introduced for a second reading by Lord Scarman.
Sorry, page?
1075.
Thank you.
And he says, I beg to move this bill to be read now for a second time. This is a modest bill designed to give effect to a degree of law reform in a very technical field of law. It is drafted so as to give effect with certain modifications to the report and recommendations of the Law Commission. The bill contains some differences or modifications from the recommendations of the Law Commission's report, but they are all minor, save for one. The major difference is that the bill as drafted will apply to Northern Ireland. Jumping to the next paragraph. Save for that extension, the bill, with certain drafting differences, faithfully contains the recommendations of the Law Commission, and then sets out what the main intentions are. And then, fourth paragraph, the bill was introduced originally in another place, and as introduced, was much wider in its scope than the bill now in the form in which it has been presented to your Lordship's House. If I may say so, some excellent committee work in another place has slimmed down the bill. The matters that have now been removed from the bill are all of the matters which were outside the purview of the Law Commission's report. So, Lord, I mean, pulling that all together, we say that you can. There's certainly the negative point that there is no suggestion anywhere by the promoter of the bill that there is an intention to expand the bill. So you can't derive a purpose or an object from what was said in Parliament. That's the negative point. I would go further. I would say that the sections I've taken your Lordship to indicate that there was a positive intention to restrict the bill substantively to the measures recommended by the Law Commission, other than drafting differences. And in relation to 7.3, there is a positive statement by the promoter of the bill that insofar as 7.3 is ambiguous as to its scope, which indicates clearly what its intended scope was, namely to deal with existing common law rights and not, therefore, foreign rights. Now, Lord, if there was intended to be a change in the position from between the Law Commission's report and the Act, it was a one so subtle that it failed to be noticed by any commentators or indeed the Law Commission at the time, which I would perhaps suggest is not a promising start to say that something is so plainly to be implied from the terms that the choice of law rule should be disapplied. And Lord, I can deal with this quite quickly. We can see that in Law Commission working paper published in 1980 on limitation in private international law. Again, where Professor North was the Law Commissioner, page 1009. Page 1010, they deal with contribution. The section starts, and the relevant bit for our purposes is at 1012. And at the end of 75, accordingly, we now consider the extent to which the Civil Liability Contribution Act applies to contribution claims involving foreign elements. So specifically now considering the Act. First, it should be borne in mind that the 1978 Act will only apply to those claims for contribution involving rules of private international law where the law governing the contribution claim, as opposed to P's right of action, is English law. There is no direct English authority on the law to govern a contribution claim, but the better view would seem to be that it's a matter to be governed by the proper law of the obligation. And there's a reference there to Dicey and Morris, indeed Cheshire and North, who also, that's in the bundle, also make the same point at the time. And then under 77, it's clear that the Law Commission in fact did consider section 1.6. If the contribution claim is governed by the 1978 Act, liability under that Act to make contribution requires the liability of D1 and D2 to be such that it has been or could be established by an action in England and Wales taking into account the rules of private international law. So the court's considering 1.6. But anyway, clearly, contemporaneously almost, the Law Commission have not understood that their the effect of their recommendation being brought into act has been to change the position in relation to choice of law. And if one then moves to the Law Commission's report, working paper on private international law and tort, at page 1014, and this was obviously the mammoth piece of work that led to the 1995 Private International Law Miscellaneous Provisions Act. And whilst we don't have the introduction here, I mean, this is a veritable cohort of eminent practitioners, which one can see from the introduction. It included Professor North, Mr. Lawrence Collins, as he then was, Professor Morse, Professor Anton, all sat on the working party. And if one turns to page 1015, one sees the start there of the section on contribution. And then under 2.83 on 1016, the Act contains no general choice of law rules and may be taken not to apply directly to all claims for contribution arising in a court in England and Wales or in Northern Ireland, but only to such claims as are governed by English law or Northern Irish law, respectively. And it refers back to this point also having been made. But clearly, it's an acceptance by those learned authors of that point. Interestingly, given the reference to the Scottish case, 2.84, in Scotland, however, it could be argued that Section 3 of the Law Reform Miscellaneous Provisions Act 1940 requires a Scottish court to apply the rules enunciated by that section as part of Lex Fori to all claims for contribution coming before it, whether or not the claim is governed by Scottish law. And that's obviously a statement which predates the Comex Holdings case, and in fact rather anticipates the conclusion of the rather different wording of the 1940 Scottish Act. And that's how the position stood until the Arab Monetary Fund and Hashim case, and all the textbooks continued the position that they assumed that this was subject to contribution to the relevant rule of contribution. And can give your lordship the reference to the 12th edition of Dicey and Morris, 1993, 15 years after the Act, page 1091 and 1093, referring to the Bonati and the Capitan Georgis, but at the same time making the same point about it being subject to the applicable law. Certainly, there'd been no assumption that the position had changed by reason of the Act in the interim. Lord, I don't actually intend to say anything about the Arab Monetary Fund and Hashim case for two reasons. First is the substantive submissions on construction you've already heard from me. And of course, that was a case where the court didn't, in fact, apply any form of presumption at all. In fact, didn't consider the presumption. So, to be fair, it was obviously a case before Cox. But in my submission, it doesn't provide any assistance. And indeed, in that regard, Lord Justice David Richards was right to say it doesn't really advance matters, given the judgments that one now has in this case. It does obviously set the sea change in terms of academic writers seeing the point that's being made that the 1978 Act is said to have overriding effect. My Lord, what I will do, and I could probably take your lordship to the first one before lunch, is just take your lordship to a few of the academic commentaries following Hashim. And the first one I was going to take your lordship to was a section of Miss Adrian Briggs's book on conflict of laws at page 1217. Contribution as restitutionary issues. And one turns over the page, and he sets out there the principle that it should be subject to the applicable law. But he then, halfway down on page 1218, says this: but it has been held that where the claim for contribution falls within the statutory wording of the Act, this regime applies with regard to choice of law. As a matter of statutory construction, This is questionable, for there is no particular reason either deduced from the wording of the Act or from the policy involved to consider that Parliament intended contribution rules to be applied to each and every respondent brought before the English courts, any more than it intended English rules of contributory negligence to be applied with equally indiscriminate effect. The correct analysis ought to be that such a claim is restitutionary and that choice of law is well within the framework for restitutionary claims. And perhaps if I could just take your lordship to the final Professor Briggs' article, page 1297. This is his Lloyd's Maritime Law Quarterly article on Arab Monetary Fund and Ashim, which repays careful reading, as it often does, from Professor Briggs. But what I would highlight to your lordships is the paragraph at 1302. So having considered that the court should take a broad approach to jurisdiction in terms of allowing parties before the court, he then goes on a few lines down, 1302. But second, this pragmatic encouragement to take a wider than usual view of jurisdiction should lead to a greater than usual sensitivity to issues of choice of law. This is, after all, the very foundation of private international law. The blanket application of English law to the substance of a contribution claim is inappropriate, at least in cases where the claim, when seen in simple isolation, would not otherwise have belonged within the jurisdiction of the court or to English law. In other words, the relationship created or arising between D and R should be treated as self-contained and the law appropriate to it selected to govern the claim. And no doubt it is then true to say that this should be the law with which the claim for contribution has its closest and most real connection, and two, that such claims should be accommodated with the emerging choice of law rule for restitutionary claims. Well, I see the time.
Very well, then. We'll resume at 2 o'clock.